Good morning, everyone. So today I thought I would talk a little bit about pesticides, our authorities, and some special issues that relate to their use um, as a township. So let's see. Jumping right in, we're going to talk about our responsibilities and sort of what powers we have over these. We're going to talk about some potential pitfalls and special issues. And then we're going to be talking about changes to Minnesota's noxious weed law, which has sort of changed pretty substantially, I would say, or at least changed enough to be worth talking about here. So jumping right in, we have the authority to control weeds and this is sort of placed on us through a variety of mechanisms. So first and most obviously, we've got a standing obligation to cause all noxious weeds on their respective highways and streets to be cut down or otherwise destroyed or eradicated as often as may be necessary to prevent ripening or scattering of seeds. That's Minnesota Statute 160.23. We also have sort of standing responsibility to eradicate weeds on township-owned land, Minnesota Statute 18.88. And then, of course, as weed inspectors, we have responsibility to sort of enforce the control of noxious weeds, even outside of township-owned land specifically, but lands that are within the township. Now, none of these laws explicitly say you must use a pesticide in order to accomplish this. Nevertheless, as a flatly practical matter, considering the amount of road mileage we have, considering the amount of property we're potentially covering, there's just not much in the way of practical alternatives to an herbicide. It's not like we can pay somebody to go there with a shovel and dig them all out individually, right? Um, so we're in this position where, as a practical matter, we have to use these things. Nevertheless, there's case law that has developed over time, which has pretty severely constrained our authority over these substances. So the classic case on point here is Minnesota Agricultural Aircraft Association versus the town of Mantrap, which basically says that aside from some limited zoning type powers that we have with this respect, the state has essentially occupied the field here. So this leaves it in a position where we functionally have to use these things. We don't have much in the way of special exemptions or special rulemaking powers. So we have to comply, for example, with licensure authorities in the Minnesota state statutes. So if you're using a town employee to do this stuff, a non-commercial applicator license is okay, but a hired independent contractor, which you're probably going to want to use for other reasons that we'll get into, has to have a commercial license. You can't just use a farm license. Now, these things carry with them certain risks. It's just the same as any other activity that we engage in as a township, of course. But because of some of the special issues associated with these things, it's sort of worth teasing out these theories. There are a ton of potential theories that a plaintiff can use, but some of the classic ones are trespass, which is you entered my land, and by the way, this includes just sort of physical particles, right? So it's not just you physically walking into my land. It also includes stuff like, if there's a particular matter that crosses a boundary, that potentially can count. Negligence is the classic. You have a duty of reasonable care. You breach that duty. It injured me in some way, and there were damages that resulted from that. So if you have a township employee and he's spraying someplace that he shouldn't, a reasonable person wouldn't have done that. You can potentially be found liable through respondeat superior theory in that context. Nuisance sort of can cover what you might think of as non-trespassory interference with land. So, the classic example of a nuisance would be somebody who's using their property in a way that messes with land, but not up to that physical level. So smells, noises, interfering with light, stuff like that. Pesticides can sometimes qualify. Now, I want to be clear, this is not an exhaustive list, but it'll be, I think, clearer over time why I highlighted trespasses specifically. Now, there are things that are worth thinking about specifically here. So pesticides have a slow feedback mechanism. So if we're using these things wrong, I spray outside of the road easement and I kill a bunch of trees or what have you. It's not going to be immediately obvious that I've done that, right? If I drive badly and I hit your car, right? It's very clear I've screwed up, something bad's happened. Now I'm stopping the activity. That's not true in this context, right? So if you spray wrong, you're not necessarily going to know that you've done that until stuff starts to die that wasn't supposed to die, right? So this can create some nasty issues. There's also the issue of latency period. Now, this is more relevant to sort of the applicator themselves, and I'm going to be advocating for folks to use that independent contractor relationship when they have the opportunity here. But it is also worth noticing. So these things can potentially have impacts on human health, and these impacts tend to be very slow, right? So if you're doing this thing year after year after year, and somebody's getting sick, but it's taken years to find out, you're going to continue doing the thing that's causing the injury without knowing that you're doing that necessarily. It's something to be aware of as a potential issue here. Now, so let me talk about why this can matter. So, for example, under a couple of theories, and particularly related to trespass, trees in this state are expensive. So, particularly when you're out in a rural area, someplace where there are a lot of mature trees, right? If you're spraying a whole rural township property and you're getting a bunch of trees, this stuff can add up relatively quickly, particularly because the Minnesota legislature in its infinite wisdom has decided to give these things special protection. So I've got a couple of statutes there. We got some relevant quotes here. Whoever without lawful authority cuts down, carries off any wood, underwood, tree or timber, girdles or otherwise injures is liable in a civil action for treble the amount of damages. There's another one. Whoever shall carry away, use, destroy any wood, timber, lumber, hay, grass, or other personal property without lawful authority shall be liable to the owner for triple the amount of damages. So let me show you how crazy this can get. So this is the just happens to be the most recent published case that I was able to find. It's from 2024 December, so it's a pretty fresh here, down from the Minnesota Court of Appeals. And what we're talking about is just this little. Can everybody see my cursor? It's this little area right here, which I think everybody can get a sense if you're doing like a rural property and you get the entire edge of the property on a road, like you are going to kill more trees than is at issue here, right? We are not talking about a whole lot of land. But in this particular case, a jury ended up finding that the owner of Lot 4 wrongfully took trees from Lot 3. They valued those things at $49,000, and then the district court trebled it for $148,500. So when we are using pesticides, if we're using something that can potentially kill a tree, it is important to be very careful because of that bad feedback mechanism or that slow feedback mechanism, and because of this potential for triple damages here. Nevertheless, there are ways to mitigate the risk. So Maddie has talked about in the past some of the use of township immunities. We're not going to get into that, but be careful about those, pay attention to them, and try to craft your policy in a way that maximizes your protection there. But the other big one in this context is the use of the independent contractor relationship. Now, in general, we are at least potentially responsible for the torts of our employees, but independent contractors, general rule is they tend to be responsible for their own torts. Now, this is a confusing and complicated area of law, but the big deal here is if you are controlling only outcomes, you are likely looking at a true independent contractor relationship. But the more you start coloring into I want to control the means that you do this by. I want to control the manner that you do this by. You're moving the needle closer to that employment relationship. And then, of course, if you want to create a genuine independent contractor relationship, it's also important to have a written contract. I mean, that seems a little silly, but I think a lot of these things are done, in my experience when talking to folks throughout the state. A lot of these things are done on a very informal basis, right? It's just we've got a local guy, he's got a license. We're just going to say, all right, we're going to hire you for this, that, the other thing, and we're not going to care about it because mostly it's not a problem. But in cases like these where there is the potential for some eye-popping damage numbers, it's important to actually create that written contract to very carefully delineate the relationship between you and that person, as if we are going to be trying to use this independent contractor rule as a way to keep ourselves, potentially safe here. Okay. So the next thing that we're going to talk about is changes from the 2025 session to Minnesota's noxious weed law. Now, of course, as we were talking about earlier, Minnesota has long required township supervisors to act as weed inspectors with potential penalties attached, specifically to the non-performance of those duties. There's not a whole lot of law about whether or not under the circumstances under which we can use pesticides, but in general, it's within the discretion of the weed inspector themselves. As part of that, a particular township decided to spray a particular area, at least allegedly. Now, I want to be clear here that this one is still under litigation, so we don't entirely know what the facts are. Nevertheless, so the allegation here is that pesticides were used on township property. Pesticides allegedly drifted past the road easement and caused injury to some individuals on the property itself. Allegedly caused some damages to trees. Owner was upset, asked for a bunch of information. Township allegedly didn't provide it, and then the resident happened to be a relatively politically connected individual, so they got a pretty unflattering piece broadcast on Fox 9. You can check it out on YouTube if you're curious. I'm not going to repeat it here because, quite frankly, I think it's pretty unfair, and I don't want to publicize it anymore. But in any event, the legislature, being the legislature, jumped into this thing with both feet. And originally, the idea was to strip us of our Government Data Practices Act exemption. Now, there's a lot wrong with that proposal, not least it would be just incredibly burdensome. Quite frankly, it's a law that is just not designed for townships. We don't have the administrative capacity to actually process applications at anywhere near the rate that they would want us to. So this would just be a huge potential liability. We managed to get that one shot down, but they did end up modifying the noxious weed law in a way that's not super ideal. So here is the new language. So what you're seeing right here is quote from, so it's chapter 39, it's article 10, and this is the portion of the noxious weed law that used to clearly protect us from trespass actions. Remember, one of the theories of liability that we can use in the context of a pesticide, if we are a plaintiff, is that trespass theory, right? So to administer and enforce the noxious weed law, an inspector shall contact a landowner through direct communication prior to entering upon the land for a noxious weed inspection. If the landowner cannot be contacted, an inspector may enter upon land without consent of the owner, without being subject to action for trespass or any damages. So then they tell us what direct communication means. So in-person visits, okay, phone calls, okay, voicemail, text message, mail, email. Landowner cannot refuse an inspector having probable cause to conduct an inspection for noxious weeds upon their land. Okay, so what's different? Now, for folks who are using this thing, if the landowner isn't present, so we make an attempt to directly communicate with this person, arguably not much. So we have to make one of those direct communication attempts before we can enter. We have to leave a report when we depart. So relatively straightforward. But If the landowner is present and objecting, then we are in some fairly uncharted territory here. That language sort of implicitly creates a probable cause standard. And if you don't meet that probable cause standard, then you potentially are looking at trespass liability, which if you are using pesticides to control the weeds on that property and you didn't have probable cause, now all of a sudden your protections are potentially stripped. So that makes it fairly important to understand what this concept is and where it comes from. Now, I can tell you, as an old criminal practitioner myself, this has never been applied to this area of law before, and frankly, it's a pretty bad fit. Criminal law in the state of Minnesota is highly litigated for a lot of reasons. There's a ton of opinions about this, and it is somewhat internally contradictory. You will find different standards being applied in different contexts. It's not the kind of thing that's a good fit for, frankly, lay people, because even trained law enforcement personnel, even trained attorneys, judges, they screw this up all the time. Nevertheless, there are some hard points in it that we probably can say with relative certainty, and one of those is this. In my view, if you want to be as safe as possible before doing this stuff, and that's probably a good idea, if you are laying eyes on a noxious weed on this property from a public place, you've got probable cause to believe there's a noxious weed on that property. It's a direct observation. There's no Fourth Amendment implications. We're viewing things from open fields. So if you want to maximize the protection for yourself as an individual and for your township, the thing to do is you lay eyes on that noxious weed, take a photo from the public area, take another photo that it makes it easy to identify the specific species that you're talking about. And then keep those with your copy of whatever report you end up generating, because you do want to be able to prove this stuff up later. You don't want to end up in a situation where it's just, oh yeah, I'm pretty sure I thought that photo went with this report. Remember, courts take a long time, and it might not be, it can be literally years between the moment where you are taking that photo, where you are seeing those noxious weeds, and the moment where you end up having to testify about it, God forbid. So you're going to want to make it as easy on yourself as possible if you're in that situation, and keeping organized is a big part of that. Nevertheless, given the potential, liabilities at stake here, we thought it was a good idea to update our noxious weed resource and sort of make administering this as easy as possible for you. So we have updated that resource. We're expecting to get it up on the website relatively soon. It includes a form that you can just sort of print off, keep one copy for yourself, give one copy to the landowner. And this complies with the new language. And if you can fill it out, then you can have some assurance that you are as protected as it's possible to be with a new law that the legislature just sort of threw at us and didn't obviously think through in any deep way here. So, okay, let's pop back in here. Got a couple of chats. I gotta keep us entertained, right? So might as well use those free AI images to make these things a little bit better. We had a weed inspector who recently retired. How do we get a new supervisor who hasn't seen any of the properties to have probable cause to do an initial report? Yeah. So we have two pieces before we can enter. So the probable cause piece, we have to attempt to directly contact at least a landowner before we go onto their land. So we're giving them a call. We're walking up to their door, knocking on it. We're shooting them a text message. We're doing all that kind of stuff. If they don't answer, then we have the traditional protections. So if they can't be located, great, fine. It's the same as before. You get to just get on it. The probable cause piece is only for when you have contacted that person and that person says, no, you can't go on my land. So in those cases, we can't go on the land unless we have probable cause. Now, traditionally, that means that you've got, it can't just be a hunch. It can't just be, a fishing expedition. It means you have evidence that a particular place, a particular thing is to be found in a particular place. So if you have seen from a public place where you have the right to be, as a supervisor, as anybody, if you've seen from a public place one of those noxious weeds, now you can be fairly confident that you have probable cause to believe that there are, in fact, noxious weeds on that land, meaning that you probably meet that standard, meaning that they can't keep you out if they want to. Now, I'll tell you, we have already been in contact with the Minnesota Department of Agriculture over this one. And we are going to try to get some extra protections, at least if we can't get that language rolled back next session, we're going to try to get some extra protections rolled into this thing. So we have at least a tentative commitment that we can, that we're going to be working together to potentially amend this thing. So hopefully it won't stick around for too terribly long, but nevertheless, I mean, just given the potential risk of liability here, I thought it was important enough to get you guys an updated resource and to make sure that you guys had a sense of what has changed. Yes, I can tell you that I personally pointed out a lot of these problems to the senator who was responsible for this particular language, and he just wanted to be seen doing things. I think that's kind of what it comes down to. He wanted to be seen doing things. I mean, the original, this thing was so, well, okay. Yeah, what's a diplomatic way to put this? Suboptimal. Suboptimal. We'll go with that. Okay. Well, in any event, thank you all very much for your time and for your attention. So next time it'll be Maddie Cash, and then the time after that we have got an outside presenter coming in from the University of Minnesota, the local government technical assistance program on the best practices for maintaining gravel roads. So hopefully, we'll get something. We're trying to expand the content sets that are available to not just be purely legal. So we're going to try to get some of that engineering content, some of that more practical maintenance side content more regularly. So yeah, thanks for your time and your attention.
Graham, I think Lisa has.
Oh,
I think Lisa's going to be presenting something.
Lisa.
Hi, you guys. How can you hear me? Okay.
Yes.
Okay, great. And then Graham, I just wanted to make sure that I believe you did, but just that there's some questions in the chat. If you could follow up with the township when we're done, if you haven't already addressed it. You might not be on. Anyways, this is Lisa with Maddit. I just wanted to provide a few updates from our area. A lot of you have been getting to know Linda. She wrote emails from our mailbox, and just want to welcome her again. I know that I introduced her last week, so she's been doing a fabulous job and keeping us above waters, because today is the renewal for our CLC policy, effective 7/1/25, which is today, and it terminates June 30th, 2026. So if you guys have any questions, changes, etc., please reach out to us. But I think a lot of changes have been made prior. So thank you, everyone. And one of the questions that continue to come up is parades. Do we cover parades? It's kind of a very vague question, but what we're recommending is to have a contract for the floats, knowing that that is a volunteer situation. You are not responsible for that float. All right, have that contract agreement saying this is volunteer. If you need to, I can email you a copy of what we use here at home office, just to have them sign it. And then if someone were to get hurt while they're sitting on a curb on a private property, they're messing around, they're diving for candy, etc., that is not your responsibility. That is the homeowner's responsibility, allowing them to sit on their property. So that's a lot of questions have been coming in the last couple days. If you need a certificate of coverage, just showing that you do have coverage, we can email you a copy. And that's if something major were to happen for the general liability, if there was an error while performing, the float, the tire flew off or anything major, we don't want that. I'm just using the extreme, obviously. Please let us know, email the Maddit Insurance mailbox and we can get that out to you, because we know the 4th of July is going to be a busy week for floats, etc. So, also, if any of you are on and have not paid your work comp, late fees and cancellation notice have been sent out. My apologies, the worst part of my job, but we have to get it done. So, any other questions, please let me know. Reach out to Maddit Insurance at mntownships.org, or just my personal email is lutley@mntownships.org. Thank you, and I hope you have a happy and safe 4th of July.
I'd like to be able to come in with a few answers to some questions here, if that's possible. This is Gussie Krupp with Minnesota Association of Townships, lead trainer. I've had quite a few questions recently about UEI renewal. And most people who had storm damage last year, was their first time to go and get their UEI at sam.gov. So we have to renew every year, renew that number. You have to go in and renew it. And if you don't do that, then you got to start from the beginning. And what I'm going to do is I'm going to post here some information. If you look at this information, there's going to be, this is at the, when you do your registration, this information is there, but if you don't know how to go back in and get it, I'm going to give you this now so that you have a chance to go find it. Let's see here. Just want to make sure you're going to have this. And this is for your sam.gov renewal for your UEI number. Remember, you need that UEI number for applying for FEMA, for HSEM, for USDA loans. You're going to be asked for this number. So make sure that you have, if you haven't applied for it, that you do. If it's time to renew it, use this information. Also, a little information about paid leave. That's constantly changing. Just got more information today on paid leave. And I'm going to give you a link also for the paid leave information, because paid leave is, it's coming down the pike here. We don't have a choice. We're going to have to apply for it. We're going to have to get our information in. As of the 1st of the year, everything starts with that. And the paid leave is not, it's kind of a moving target right now as far as how much we're going to have to pay. 88% is the newest information I got to begin with. But this information that you're going to find at the deed website, the unemployment insurance deed is handling the questions for the paid leave. And I'm going to have their phone number. They're great to work with. And I'm going to also put up some, these are just some helpful Q&As for individuals and for the employers. So you need to go there and you need to find out what's the newest thing. And I'm going to give you, there's a premium rate. You can actually calculate your premium rate. I'm going to also put that link in chat also. So hang on for that. Okay, so there's some information to start with. And if you have any questions, be sure to call myself and the other trainers. We're all educating ourselves right now so that we can answer your questions and make sure we can keep up to date, keep you up to date. That's all I have.
All right. Well, if there are any other questions, do please feel free to reach out. Otherwise, thanks and have a nice afternoon, everyone. Happy 4th of July.